Hello, I'm Payal Chawla and welcome to my video podcast, Navigating Commercial Disputes, brought to you in association with Bar and Bench. In this podcast, I aim to break down complex commercial legal issues for law students, for lawyers, and for legal enthusiasts alike. Today, I will be delving into a complex and nuanced issue of limitation in relation to Section 37. Section 37 of the Arbitration and Conciliation Act is the appellate provision and deals with appeals. Section 37, however, does not prescribe a period within which the appeal has to be filed, unlike Section 34, which prescribes a timeline of 3 months and 30 days. Since the statute is silent, it was left to the courts to decide what the limitation would be in filing an appeal. This issue was dealt with, seemingly at least, by the Supreme Court in the matter of Government of Maharashtra versus Bhorse Brothers, Engineering and Contractors Limited. However, I believe that there are still some unresolved issues which may require reconsideration. But before I delve into those issues, I'd like to introduce you to Dr. Amit George, who is a thought leader in arbitration. So welcome, Amit.
Thank you for having me, Payal. I am excited to dive into this topic. It's not only legally intricate, but it also is of immense practical consequences in terms of daily practice in arbitration.
Amit, before we get into the issue of Bhorse Brothers, wasn't the issue of limitation in Section 37 already decided by Union of India versus Varindra Constructions?
Yes, so a two-judge bench in Varindra Constructions essentially held that an appeal under Section 37 is subject to the same rigid time frame that's applicable to a Section 34 petition, that is 3 months and 30 days. Now, the interesting uptick of this finding is also that similar to the prohibition for any sort of a condonation of delay beyond this 3-month and 30-day period, which is applicable to a Section 34 proceeding, a similar limitation would then also come into play when it comes to filing appeals under Section 37.
What was the rationale behind the decision of Varindra Constructions?
Well, I think fundamentally the court went by the underlying logic that a appeal is fundamentally a continuation of the proceeding that has actually gone on in the stage below, and therefore it sort of extended the limitation which was applicable to the stage that was being appealed against to the appellate forum itself.
And was there a particular decision that the court relied on?
I believe there was a decision of the 1940s in Lacheshwar Prasad, which the Supreme Court relied on for this purpose.
I see. The decision of Varindra Construction was followed by the Supreme Court again in NV International versus State of Assam. However, the controversy arose when the Madhya Pradesh High Court refused to follow the decision of NV International in the matter of MP Purv Kshetra Vidyut versus Swastik Wires, citing conflict with a larger bench decision in the matter of Consolidated Engineers Enterprises versus Irrigation Department. However, at the same time, the Delhi High Court and the Bombay High Court continued to follow the decision of NV International and held that any delay beyond the 120 days period would not be condonable. Amit, with this background, which of these positions did the Supreme Court align with?
Well, the Supreme Court, in fact, set out a somewhat novel formulation because even though it held that the court that had declined to follow NV International was not correct in so doing, ultimately the Supreme Court on its own overruled NV International. So, Borse was a judgment of a 3-judge bench, which in effect proceeded to overrule the earlier 2-judge bench decision in NV International. So, I would not say it aligned unequivocally with either of the decisions that were impugned before it, but it set out a new formulation.
So, in effect, even the Madhya Pradesh High Court decision, the court did not align with. Is that the correct position?
Well, fundamentally it did not because it found fault with the Madhya Pradesh High Court in declining to follow NV International when that was the stated position of law insofar as the Supreme Court was concerned.
Right. So this is very interesting. So in effect, what the court in Bhorse Brothers said was that they are not going to follow the same scheme that is there for Section 34 for Section 37. Is that right?
Yes. So, in effect, the court held that inasmuch as there was no textual indication in the Act that the limitation period under Section 34 would find application automatically to Section 37, they held that by judicial determination, this sort of a limitation period could not be imposed on the statutory provision. They also recognize the fact that when it comes to appeals under Section 37, there is a wide range of orders that could be subject matter of appeal even beyond Section 34. For instance, Section 8, Section 9, etc. Therefore, when there is this diversity of orders that may potentially be challenged under 37, the court found that imputing one uniform form of limitation derived purely from Section 34 was probably not apposite.
I see. So, but then the court went ahead and said that the statutory limitation, in a sense, for Section 37 could be either 30 days, 60 days, or 90 days. So, which one is it, and how? What are they exactly saying about these three different types of limitation that could apply to Section 37?
So the court effectively recognized this differentiated regime that operates insofar as the Commercial Courts Act is concerned. So when it comes to matters emanating under the Arbitration Act but which are subject matter of the Commercial Courts Act, there is a uniform limitation period in terms of appellate jurisdiction, which is of a period of 60 days. So the court held that when it came to matters that were governed by the Commercial Courts Act, the limitation period would be 60 days. For matters that were not so covered, the court noted that even otherwise there was a regime of there being a twin track in terms of limitation. If the appeal was to the High Court, then the appellate provision provides for a limitation period of 90 days, and to any other court the provision is of a appellate limitation period of 30 days. So because of this, in that sense, differentiated regime, in effect today the limitation in terms of appeal under 37 could be 60 days, 90 days, or 30 days, depending on the peculiar fact context which you might be reckoning with. So the court notes that this is something that is a result of the legislative framework and that there is nothing arbitrary in this, because ultimately appellate periods or the limitation periods are something that is governed by statute.
So, Amit, in effect, when litigants as well as legal practitioners are filing an appeal, they need to be mindful that there could be three different statutory limitations that could apply to a 37 appeal?
Correct. So therefore, today, unfortunately, even though this should be the case legislatively, there is absolutely no certainty in terms of what would be the limitation period for your appellate provision. And that would be completely determined in terms of your fact context. So as you rightly said, ma'am, a Section 37 appeal, depending on the context, may vary from 30 to 90 to 60 days. So therefore, practitioners need to be mindful of this to avoid being blindsided.
Now, suppose a practitioner were to forget this timeline or were to get it wrong, would it mean everything is lost, or do they still have an opportunity to approach the court?
Well, Borsay does leave open the possibility for a possible condonation of delay because it holds that Section 5 of the Limitation Act continues to apply to appeals under Section 37 even if they are framed under the Commercial Courts Act. So, effectively, if you are able to bring out a bona fide reason for explaining the delay, your recourse to Section 5 of the Limitation Act continues even though you may be articulating an appeal under the Commercial Courts Act within Section 37.
But doesn't Borsay Brothers also say that this is not a timeline which is without any fetters? And that concerns me a little bit because the statutory language of Section 5 doesn't impose that fetter, but Borsay Brothers appears to do so. So, can you just explain how that works?
Yes, so I think Borsay was cognizant of the fact that leaving the application of Section 5 too open ended might end up defeating the very purpose of speedy adjudication under the Commercial Courts Act. So Borsay strikes a balance by saying that the application of Section 5 to a Section 37 appeal, which is governed by the Commercial Courts Act, would have to take into account the context and color of the underlying rationale of the Commercial Courts Act, that is speedy resolution. So, therefore, the court ultimately holds that condonation of significant periods of delay would not be permissible under Section 5 when it comes to a Section 37 appeal under the Commercial Courts Act. Ultimately, the Supreme Court does leave it to a fact specific determination by the court concerned, which might be considering that appeal. But the tenor of the judgment of the Supreme Court is that the open ended condonation that is otherwise contemplated under Section 5 should not be applicable to a commercial courts matter. And therefore, in effect, it says that courts should be wary of condoning significant periods of delay and thereby defeating the very underlying premise of the Commercial Courts Act.
So, and I recall that in Bhorse Brothers, the Supreme Court says that that play is available under Section 5
Yes.
In order to be able to decipher in which statutes you have that leeway versus those that you may not have so much leeway. But it concerns me a little bit that it is just too subjective, and it could be from court to court. There would be no uniformity vis-a-vis a 37 appeal. Is that correct?
Yes. So now, because this exercise of discretion is sanctified by the Supreme Court, effectively every court is entitled to examine in the peculiar circumstances of the case before it what is the period of delay which it can condone, finding that delay to be bona fide. So you're absolutely right, ma'am, that there is no Lakshman Rekha now in that sense, beyond which a condonation cannot happen. And already, if you see various high court judgments that have applied Borse, the range of periods which have been condoned range from a month to several months. So you're right. This, I mean, does lead to an element of subjectivity and exercise of untrammeled discretion in certain cases.
So while I know that the Supreme Court is currently in season of this matter, although they've gone on the view that it's Envy International and not looked at Bhorse Brothers, but I assume that subsequently this will be brought up before the Supreme Court. But do you think that since they are looking at amending the 1996 Act once again, this is an aspect that the legislature should look at?
Yes, so this is exactly what the bench in Borse also notes, that ultimately many of these predicaments are for the legislature to solve, and that for courts to get involved might not be appropriate in this particular framework. So, as you rightly put it, ma'am, that this is something that needs to be addressed because there is a lot of potential for confusion because of the regime for limitation that applies today. And this unnecessarily eats up a lot of precious judicial time, which could otherwise be devoted to actually hearing the merits of the matter itself.
Amit, I know you argued this matter and particularly the aspect of Hongo, and I know that you're not comfortable talking about this. So, but I have a little bit of a concern with the final holding of Bhorse Brothers, insofar as the court distinguished Hongo, because the court says that in Hongo, 180-day period, which was prescribed by Section 35H, was an outer limit, was a significant period, as opposed to the other sections of 35, that's 35A, B, and C, which had prescribed a limitation plus given the court the power to condone the delay. As opposed to that, in Section 37, the periods range from 30, 60 and 90 days, and 60 days is an intermediary period between the 30 and 90-day period. But my concern is twofold. One, the Arbitration Act is a complete code in itself, like the Central Excise Act. And secondly, the Section 5 would also apply to the 30-day period as well as the 90-day period. And perhaps the legislature does need to reconsider this aspect, in my very humble view.
Yes, I think the government is currently seized with potential amendments that it might want to bring to the Arbitration and Conciliation Act. So, this is also possibly one of the arenas that the government might tackle, so as to ensure that there is one unified or uniform regime when it comes to limitation periods under Section 37.
Amit, thank you so much for being part of this conversation. I've thoroughly enjoyed our episode today.
Thank you so much for having me. I mean, the pleasure is all mine. Thank you.
This concludes today's episode of Navigating Commercial Disputes. Do stay tuned for more in depth conversations on the issues that matter most. Thank you.